I'll call the next case on the list. Okay, next case is case number 2022-0971, Dana DUPRAS versus Charles Cullen. And before you start, sir, I realize that you were in the courtroom earlier today when I read the names of the party just beforehand. But as an officer of the court, I'm sure that you understand that that the case was partially impounded.
Yes.
Okay.
Yes.
Thank you. All right.
Excuse me. May it please the court, I am Attorney Paul Patton, representing the appellant in this matter. This case is here on a report pursuant to Mass Rule Civil Procedure 64A by Judge Hussain in the Bristol County Superior Court. It involves the question of the impact of the U.S. Supreme Court decision of National Pistol and Rifle Association versus Bruin. And if I may, I'd just like to say at the outset that the issue here is not an issue of pro-gun or anti-gun, nor is it an issue by which, certainly on my part, ignores the fact of the obvious incidents that have occurred of multiple gun murders, if you will, that have been going on. What it has to do with is how a specifically enumerated fundamental right contained within the Bill of Rights is going to be treated in that in the Massachusetts gun licensing regime in light of the Bruin decision. And in this regard, I will bring to the Court's attention that approximately 3 weeks ago, the SJC did come down with a decision, Commonwealth versus Godado, which, although it was in a criminal context, does reach the initial basic factor that has to be considered in the discussion of this issue. And what that factor is that up until Bruin came down, the presumption in Massachusetts regarding the provisions of Chapter 140, Section 131 in particular, was that the decision of the Supreme Court back in District of Columbia versus Heller, in which the Second Amendment was found to be a fundamental right for the general population to carry a gun within the home for self-defense. Subsequently, in the decisions of the SJC, and had been the assumption that that did not apply to carrying a gun outside the home. So it didn't apply to the full license to carry law, which is what is the issue here. However, as the SJC acknowledged in Godado, what that resulted in was when it came to the issue of issuing a license to carry a firearm, that was not based on any general right of the public to carry firearms. It was the opposite. the assumption, the presumption, up to the time of Bruin, was that there was no right for the general public to carry a firearm, and that the licensing laws were intended to provide an exception to that for people who qualified as specified in the statute.
So, Attorney Patton, that goes to the good cause part of the statute, right?
Yes, yes.
Which has been eliminated at this point.
At this point, what happens is, what had happened was that once Bruin came down, and this, again, I'm referring to what was pointed out by the SJC, is that that concept was reversed. That, in fact, in light of Bruin, even under the Massachusetts statutes, that there is a general right of the public to carry firearms, but the licensing law acts as a restriction and burden on the exercise of that fundamental constitutional right.
But isn't Bruin focused on the portions of the statutes in the 6 states, including in that case New York, that dealt with the good cause?
Yes.
The unfettered, in situations where there was unfettered discretion to deny or revoke?
That's correct. That's correct. But what Bruin also did in doing that was make clear that the Second Amendment right as articulated in Heller applied outside the home. And when it comes to to using the licensing laws, that yes, there cannot be unfettered discretion to a licensing authority in terms of giving or withholding a license, or in this case here, suspending a license.
But in Massachusetts now, as the statute stands from a facial point of view, the discretion of the licensing authority is limited to determining unsuitability based on specific, credible evidence that suggests that the person, paraphrasing, is a risk to public safety, correct?
Well, what happens in the statute is that on the unsuitability issue, and certainly at the time that this case originated, this was before the amendment that took place on August 10 of 2022 in response to Bruin, that the requirement for unsuitability was that there be reliable, credible information that suggested to the licensing authority that somebody may be a danger to themselves or the public if they are allowed to have a firearm. The only change that came about with the amendment in August of 2022 to that language, effectively, was they added in that the information also had to be articulable, which raises a real issue of questioning what was the standard prior to that it didn't even have to be articulable. Could it be a hunch on the part of a police chief? Could it be a gut feeling? I don't know. You can't tell from the face of the statute. And you can't tell from the decisions that have come down over the years by this court as well as the SJC dealing with these issues, because, as is quite clear throughout them, everything was based on a rational basis analysis. And that rational basis analysis was certainly one that was rejected by Heller within the context of what Heller, the area it applied to. But it's also been outright rejected by the Supreme Court in Bruin. Now, that brings us to the
Let
point.
me just take a step back for 1 second, because I'm curious as to how this case really even got here. Because, correct me if I'm wrong, but under Rule 64, for a reported question, my understanding is you really need two things for a reported question. First, you need an agreed statement of facts, and the second is you need a question. It's posed to the court. And I'm having trouble finding, one, the agreed statement of facts in the record, and I don't see a precise question that's been posed to us by the trial court.
Well, let me say to that, Your Honor, what happened here was that when we were in the Superior Court and there had been a motion for judgment on the pleadings filed in accordance with the Superior Court rules. And when Bruin arose, a motion was made on my part, assented to by the others, that I now be able to bring up the Bruin issue. What eventually happened was when we were before the court, before the judge, on 2 occasions, he had status conferences in court on the record. He is the one that recommended to us, not just to me, it was not my initiating it, but to myself, to Attorney Howiak, and that we request that a Rule 64 referral be made. Now, the problem with that is that in drawing up the request, it comes back to this issue of the overall impact of Bruin. In other words, certainly within the case, what we're dealing with is the issue of unsuitability. But that issue, in turn, gets affected by what is the overall impact on, of Bruin on the licensing scheme itself. And all I can say on that, I had never done a Rule 64 before. I'd never had occasion in 43 years to deal with that.
Sure, I'm not suggesting anyone's, dropped the ball here or anything. I'm just trying to understand the precise question we're being asked to answer, because otherwise we'd kind of be left to be formulating the question on our own, and I don't think that's proper under Rule 64. And the reason I ask that question is this. As I read the record, there seems to be a dispute of fact. So, for example, the plaintiff has claimed that the trigger lock was in place and that the firearm was unloaded, and the police say the exact opposite. The plaintiff has also denied making the statement to the person on the phone about wanting to do himself injury. Those seem to be kind of critical facts that have to be resolved before an appellate court can be involved, wouldn't you think?
Well, I think what it is that in the Superior Court and the certiorari, what the court does is it doesn't look at new facts. It doesn't make decisions of fact. It looks at what happened in the district court. What did the district court judge decide? And did he make an error of law in his decision? And in that sense, the facts, if you will, before the Superior Court was what was the record. Everything you just mentioned is in the record there. There's no question that yes, there was testimony by CULLEN as to one thing. There's testimony by DUPRAS as another thing. Right? But that was not the issue before the Superior Court. The Superior Court issue was strictly looking at the record there, taking that record, and then looking at the trial court judge's decision. And given what was on that record, was that decision compliant with applicable law? So in other words, it's the question of, okay, fine. There was an open question about the whether or not the gun was secured, whether or not there was a trigger lock on. There was not, the purpose in the Superior Court was not to get an answer to that question. The purpose in the Superior Court was, given that evidence there, given that testimony, that record there, was the judge making a correct decision as a matter of law when he upheld the suspension? So it's a step away from the actual factual determinations, which are what take place in the district court. So
you're saying there's some implied factual findings by the district court judge. Is that what you're saying?
Well, yes. I mean, the district court judge, the problem that I have on his part is that, as he said on the record, the only evidence I've heard here on the issue of securing the gun was the testimony of the of Mr. DUPRAS, and he says it, that the quote is there, and I think it's only an issue of the Section 12. That's what he said. Mm-hmm. When he came out with his decision, he says, no, Section 12 did not provide a basis for the suspension, but the way he puts it is, I can't say that there was no support for the allowing the suspension based on the failure to secure, which again comes back to the issue of unfettered discretion.
So, Counsel, I think you've answered the question, and so you're over your time. But I don't want to cut you off or cut off. Okay, the question's been answered as far as he's concerned. Any further questions? We're all set. Thank you very much.
Good morning. May it please the Court, my name is Gary Howiak, and I'm not under the weather, but no matter what I take, the allergies this time of year just get to me, so I apologize. To start off, I think you asked a very important question, what is the issue here? And I think the issue is not as complicated as my brother indicated. The issue here is simply whether the district court committed substantial error of law. That's the standard, based on the evidence that he had before him, Judge Finnerty. The Superior Court, frankly, could have resolved that issue, and then when Brune came, I believe everybody was confused, including the Superior Court judge, whether Brune played a role in this. The more I look into this issue, I do not see Brune as a factor in this case. The question really on the appeal is whether Judge Finnerty, when he concluded, as my brother indicated, considering the foregoing, this court cannot conclude that there was no reasonable ground for suspending the license. To me, the only question really is with the evidence that was before the judge, was that enough for him to determine that the licensing authority, when they made their decision to say that this individual was unsuitable, whether that decision was arbitrary and capricious?
Well, can you tell me what is the reported question that we're being asked to decide? Because it's still not clear to me. What is the question? Because you've referenced the Brune case. Because as I read this, it looks to me like the Superior Court judge looked at the motion that was filed, was assented to. It didn't identify a precise question that had to be answered. And the Superior Court judge just said, well, you know, I'm going to allow that motion to report the question. Yeah. But the judge never articulated what the question was. Would you agree with that?
I agree with that, and I believe you are in essence in the shoes of what that Superior Court judge had to decide, which was the issue of whether the judge committed substantial error of law.
standing alone or in light of the Bruin case?
Well, gee, I would think both, because the reason why the judge, Superior Court judge, brought it to this level is he wasn't sure how the Bruin played a role. And I believe the Superior Court judge basically said, hey, whoever loses here is going to appeal it, so let's just have the appeals court decide the issue. I think that's kind of...
Let me ask you a question just substantively, because I was troubled by some testimony of the police officer, the deputy chief, when he was asked, when can the plaintiff get his license back? And the answer was something like, well, he can get it back in 2025. He can reapply in 2025.
Right.
And the question was, well, why? Why would he have to wait that long? Well, because that's, the way we do things. That's when his license would have been up for renewal anyway. Doesn't that bespeak arbitrary and capriciousness? That it's just at the whim of the local department of when you get to reapply?
Well, I think that would be an excellent question had the plaintiff reapplied and it was denied, and then that was the response, come back in 2025. That wasn't the issue before the court. I recognize that it's a problematic response in the eyes of the court right now, but that wasn't the issue at hand. When he's going to get it back? The issue was whether it can be suspended.
But this goes to the Bruin case, because what if, hypothetically, putting aside all that has happened with the plaintiff in the past, what if he's just John Q. Public and he goes and he applies now for his license? Would he get it?
Well, at the application stage, they would have to make the same determination whether there was any reason that he would be an unsecured.
And there isn't. There's no categorical reason why he wouldn't get it, right?
At that point in time, well, there still would be. The police report indicated there was an unsecured weapon. So the question really is, how long does that piece of factual evidence become material as time goes up by? And
right.
So I suggest as time goes by, it becomes less and less germane or relevant.
And who says that?
Well, that has been the discretion of the licensing authority.
And isn't that inconsistent with Bruin?
Well, no, I don't think so, because I don't think Bruin, unless I'm misreading Bruin, I think Bruin was really focused on, you can't have this question, why do you need a gun? That's not good enough. It's kind of almost like a litmus test. The discretion component that the chief utilized in this case was that there was an unsecured weapon. It was under the sworn statement of a police officer. The police officer's report was part of the evidence that the judge ultimately put weight upon.
Okay, but when you got to the hearing stage,
Yep.
and it's time to put on evidence, the plaintiff testified as to how he left that firearm. It was unloaded, had the trigger lock on it. Now, the city could have come in and brought in the police officer who was there and brought in contradictory testimony, and then it would have been up to the judge to weigh the competing testimony. The city didn't do that and relied on hearsay. Is that sufficient
Well, it was certainly
when we're dealing with a constitutional right?
Well, it was great question. I don't know. I mean, it was certainly reliable hearsay where the deputy chief is familiar with this officer, has relied on these officers' reports in the past, and they know that these reports are signed under the penalties of perjury. This person was even brought up on criminal charges based on that police report. So I don't believe there was any question, in at least the licensing authority's position, that there was certainly an unsecured weapon. That's certainly...
But the plaintiff had no opportunity to cross-examine the document, the police report, to probe whether the officer really saw what he saw.
Fair
And again,
enough.
we're dealing with, it's a constitutional right. And as your brother counsel had pointed out, the debate is over as far as, policy and where you stand on firearms and so forth. The Supreme Court has told us this is a constitutional right like any other constitutional right.
Fair enough. The plaintiff also at that hearing, of course, could have brought in additional testimony. The wife who was supposedly at the house at the time would have seen the weapon. She didn't appear. The plaintiff could have objected to the introduction of the police report. On the record, made certain objections preserved regarding those issues. I guess the plaintiff could have subpoenaed in the officer, but I recognize that might not have been the best strategic plan. Well, in a nutshell, I think Bruin has been remedied as far as the good cause component going forward, at least by the way of our statute. In this case, I don't believe that the judge made a substantial error of law based on his findings. He said there's no good reason. I can't say that there's no good reason. And that's based on what the deputy chief had at the time when he made the decision. So it's kind of a frozen moment in time that the analysis was done by the deputy chief. So that's all I have.
Can I ask you a few more questions about the testimony regarding the reapplication process?
Yes.
Did I understand Mr. Cullen to testify that not everybody has to wait until the prior license that is suspended, that does not have to wait until that license gets to the point where it would have been renewed, right?
Correct.
Okay, and that he said he looks at this on a case-by-case basis as to who comes in and can renew it right away or who can get the license restored earlier, but did not really specify as to what factors is considered with respect to how that comes about. Am I right about that?
That's correct. And then you could just carry it a step further. If the person came in a month, 2 months, 6 months, I recognize who knows how long thereafter, with credible, reliable information that enables the licensing authority to deem him suitable, then the application would issue sooner than the lapse of the old one, which he did testify to.
All right.
That's all.
Okay.
Thank you.
Do you have a case that says unsuitability can be based upon a lapse like here, that assuming you just didn't, you've rushed out of the house quickly as you were cleaning the firearm, you realized you had a doctor's appointment, you didn't go to the trouble to put the trigger lock back on? Because as I read it, unsuitability is usually something more serious, like there's, let's say, a prior assault and battery that maybe didn't result in a criminal conviction, but there's some level of violence involved that really gives police concern that should this person really be armed.
Right. No, I don't have a case. And to some degree, you could see how an incident such as this, having a person had 40 some odd weapons or 30 weapons, seemingly all secured but for one, has had his license since I think it was 1979. Seems like a responsible person otherwise. One would believe that if some time elapsed and everything else being equal, he would be able to get his license back soon enough. But at that time, when the police are doing a wellness check and go into the house and find a weapon unsecured and bring criminal charges, they have a duty for public safety. So at that point in time, the chief has no choice but to deem him unsuitable. When he can get his license back, you state an excellent question. I don't know how much time has to elapse.
I recall the testimony being that Mr. DUPRAS could not walk in the next day to the police station and say, I'm now suitable, that he was going to have to wait until 2025. That was how I understood the testimony at the hearing. I'll look at it again, of course, but What is your interpretation?
Yeah, you know what, I don't recall specifically whether the testimony was he had to wait until 2025, or he certainly is eligible at that point in time because his
I'll read it
current
again.
license has
Perhaps
been
I read
suspended.
into it too much. I'll look at it again.
Yeah. When his license is suspended in after 2025, whatever the date is, there's no more license to suspend. So therefore, he would be, you know, applying anew, if you will. Whether he could have applied earlier than that, frankly, I don't know how the testimony came out. I don't recall. I didn't try the case, but when I was reading it over again, I didn't recall that. Sorry.
Could the deputy chief have reinstated this license on his own? Let's say a couple of weeks goes by and the plaintiff comes into the department, and or maybe after the criminal case is dismissed, he comes into the department and says, "Look, I wasn't committed for mental health issues, and the case against me was dismissed, and I'm prepared to put the trigger lock back on. Can I get my license to carry back?" I mean, what would the police do in a case like that?
I don't think the license at that point in time would have been restored because, and I know there are cases which is cited in my brief, that it's irrelevant that the criminal charge was dismissed. The police reports themselves, there could be many police reports of incidences that don't rise to the level of a criminal charge. So those police reports are valid for evidentiary purposes, if you will, when the licensing authority determines suitability. And I'm a little troubled right now trying to think of a good time frame to say, well, after 6 months of good behavior, those police reports, when they gather so much dust, become less relevant. Time does make them less germane, if you will, but I don't have a time frame, so I can't. But I can't imagine if he came in within a month or 2 months, fresh after the police report was created, that he would all of a sudden be deemed suitable.
Mr. Cullen seemed to imply that could happen. I think he gave an example if there was a domestic dispute, but that everything was okay and there were things that gotten resolved, that would be something that would be considered. But I guess that wasn't really explored completely enough on that level.
Thank you.
All right, thank you. Just one moment. I'll just see if there's any further questions. No? Okay. All right, thank you very much.